Well, good evening, everyone, and welcome back to AJ 101 Criminal Law Online. Tonight's lecture is going to be on Chapter 7, and that's going to cover laws of arrest. Now, this is going to be one of the longer chapters, therefore, I'm going to need your help by having you read through the chapter very thoroughly to make sure that you hit on some of those areas that I'm just not going to be able to get to. My goal is to keep this lecture under 60 minutes, and in order to do that, because there is so much information, I'm just going to kind of touch on some very important things as we go through. And if you want to add more context to the conversation, you really are going to have to take some time yourself to go through and add a little bit more to that. So I'll apologize up front for not being able to dig into every single subject that we're going to talk about, but I will give you enough information to where it should make it very interesting and get your mind thinking about the subject matter itself. Also, don't forget about the student resources at the end of each one of the chapters that again will help you study for your weekly quizzes and your chapter exams. So with that being said, let's jump into Chapter 7, Laws of Arrest. Now, a great place for us to start would be to find out, if we're going to talk about laws of arrest, well, what is an arrest? And who can make an arrest? And how are those arrests actually carried out? So let's kind of start with that. So Penal Code 834 defines an arrest as the taking of a person into custody in a case and manner authorized by law. Now, an arrest can be made by a police officer or by a private person. And following up to Penal Code 834 is Penal Code 835 that tells us how an arrest can be made. So even though we're not going to dig deep into that Penal Code Section 834, I mean, we know it's a taking of a person into custody in a case and manner authorized by law, and you're probably saying, well, what is that? You can dig into that a little bit more, but this is going to be enough for now. 835 tells us, hey, here's how you can do it. You can do it by actual restraint or by submission into custody, or the officer may use what is termed reasonable force to effect an arrest. And we're not going to go through the whole use of force continuum because we just don't have time to do that, but perhaps later on in some of the other chapters we might hit on it. So now that we know what an arrest is, at least the definition and kind of who can make it, well, how does it all really start? Well, a lot of this, arrests, detentions and things, they start by encounters, meaning encounters at different levels. So this is kind of where we're going to talk about police contacts with citizens and how these things actually work. So when we talk about encounters and detentions, we talk about police contacts with citizens can be categorized, excuse me, in three different ways. So we look at these encounters and detentions kind of on three different levels, if you will. And the first level would be something called a consensual encounter. Now, this is a contact that requires no legal standard of suspicion. You don't really even need a reason to do it. And I'll give you some examples in a few minutes. Detentions, which is the next one, this is a seizure under the Fourth Amendment and requires a minimum of reasonable suspicion. And we'll identify what all these terms mean as well as we go along. And then the last one, at the top level, if you will, would be what we call an arrest. And this is also a seizure under the Fourth Amendment and requires a minimum legal standard of probable cause. So when you kind of look at these, you can see how that consensual encounter is kind of at the lowest level and how the arrest is at the top. So again, consensual encounter, you don't need a legal standard of suspicion. I don't need to suspect you of doing anything wrong. It's just a consensual encounter, meaning that you consent to me talking to you. A detention, you need something called reasonable suspicion. And it is a seizure because you're making somebody stop. And then the last one is an arrest, and that's a higher level, a higher standard, if you will, because it is also a seizure under the Fourth Amendment and requires a minimum legal standard of what they call probable cause. Now, a search and a seizure, so we've got the three different parts of the encounters, and continuing here, we'll identify what a search and a seizure is. So a search occurs when governmental action infringes an expectation of privacy that society is prepared to consider reasonable. Meaning that, we're going to search, we're going to look for something. So this occurs when we infringe on your expectation of privacy. A seizure, on the other hand, of property occurs when there is some meaningful inference by the government with an individual's possessory interests of that property, meaning we took it, we took control over it. Okay, we're not looking through it like a search, we've actually seized it, we've actually taken control of it. Excuse me. And a person, though, because this search and seizure can also be aimed at, if you will, or categorized with people, not just like a vehicle being searched or seized. A person can be seized. And how does that happen? Well, a person can be seized within the meaning of the Fourth Amendment, where the government, by show of force or other assertion of official authority, communicates to a person or an individual that he or she is not free to disregard police presence and go about their daily business, and the individual is thereby caused to submit. Hey, you, stop. That's an example of me giving you a directive, a show of force or other assertion of official authority that communicates to you that you are not free to disregard my presence and go about your business. You are not free to leave. Does that make sense? So that's a very quick example of, what it would classify as a detention, but just to kind of give you an example of how that works. So staying with this encounters and detentions, under the court-created exclusionary rule, and we'll talk a little bit more about that later, any evidence resulting from an unreasonable search or seizure is subject to exclusion from a defendant's trial. And this means every seizure, including both detentions and arrests, have to be justified by what they call a corresponding level of suspicion in order to be held constitutionally reasonable for exclusionary rule purposes. So if I just walk up to you and without any warning reach into your backpack and pull out something that you have in your backpack and it happens to be illegal, without any justification or level of suspicion or anything else, even if I arrested you for having that object under this thing they call the exclusionary rule, it would be excluded from your trial because it was seized illegally. Does that kind of make sense? And you can look up the exclusionary rule and get a little bit more information about that. But again, because of the lack of time, we're going to have to kind of, hit these high points and move through that. So now let's kind of back up a little bit and let's look at those three levels of things that we talked about before in a little bit more detail. So first, we're going to go back to consensual encounter. This is when both the police and the person enter into a consensual contact. And during this contact, the police are not limited by any constitutional issues or anything during the contact. The officer doesn't have to demonstrate any legal standard at all. And there's no need to show that the officer has what they call reasonable suspicion or probable cause that a crime has been committed or anything. And an example of this would be an officer asking a person if they would mind talking to them for a few minutes. I'm on a foot beat. I'm walking down the street. I see someone just kind of standing there. Excuse me, mind if I talk to you for a minute? And you say, no, what's up? And we talk about things that are going on or whatever. You're free to leave. I haven't detained you or anything. You see how that works? That's called a consensual encounter. Now, you don't have to consent to that encounter. You can basically say, well, I'd rather not speak to you, and turn around and walk away. And very few people do that, but it does happen. But realistically, the reason they call it a consensual encounter is because it is just that. There's no legal standard that applies to that particular encounter. So remember, though, during a consensual encounter, the person is free to leave unless you can meet the legal standard of the next highest level to detain somebody, which would be reasonable suspicion. So first you have no legal standard, meaning that it's consensual, right? We consent to talk, blah, blah, blah. Then if I want to stop you or detain you, I need what they call reasonable suspicion, that there's some type of criminal activity taking place and that you may be involved in that criminal activity, et cetera, et cetera. And then if I want to arrest you or search you, it goes up to the next standard, which is probable cause. If you want to see somebody further, arrest them or search them. So 3 levels, if that kind of helps you out. So during a consensual encounter, person is free to leave unless you can meet the legal standard of reasonable suspicion or probable cause to seize them further. A person or the person does not have to talk with you about the incident or possible crime if they don't want to. Now, under some circumstances, you do have the right as a law enforcement officer to have the person provide you with their name, and it really depends what it is. Now, if it's a detention or an arrest, then yes, they're going to have to kind of give that information up. However, if it's a consensual encounter, that window is a lot more narrow as far as identification. Now, you can always ask somebody, would you mind giving me your name? And if they do, that's great. So kind of enough said on that. So that's the first level. Now we're going to move to detention. So the Fourth Amendment of the U.S. Constitution uses the broader term known as a seizure instead of detention. A detention is in fact a seizure and requires an officer to justify their government use of force by a legal standard. And use of force doesn't mean grabbing and throwing somebody on the ground. Use of force could mean advising someone to stop. They are not free to leave, or something similar. So, or turning on your red light in your police vehicle as you're behind another car. That's going to be a detention because people know that they're not free to leave or drive away from the police when there's red lights behind them. So hopefully that kind of makes sense. So the standard, this particular standard is less than probable cause because it's a detention, and it only requires, remember, reasonable suspicion. Now, we're not going to take the time, but I would highly suggest that you look at this case, Terry versus Ohio. It's a case precedent case. It's a U.S. Supreme Court case. It's old. It's in 1968, and that's probably like ancient for a lot of you, not for me. But it's an important case as it relates to pat-down searches and detainments, and it still holds true today. So take a look at that case, and I think you'll find it very, very interesting. Anyway, now back to where we're going. The officer must be able to articulate or explain their suspicion that the person may be involved in criminal activity. And the 2 most common examples of detentions would be what we call a pedestrian stop, meaning we're stopping a person, or a traffic stop, meaning we're stopping a vehicle. So if we observe you run through a red light, it's a violation of law, and because of that, we're allowed to detain you to investigate further, to write a citation or whatever. Pedestrians are a little bit different, but if you have reasonable cause to believe that something is taking place, some type of crime or what have you, and you have that reasonable suspicion, you could actually stop them. Example, and we'll just talk about reasonable suspicion for a minute. You're on foot patrol in an apartment complex. You hear a gunshot and you see somebody running. And could that be a victim running from the scene? Sure. Could it be a suspect running from the scene? Sure. Would you have reasonable suspicion to maybe stop and ask that person some questions? You absolutely would. So there doesn't have to be a lot, but you need to have, again, reasonable suspicion. And again, the 2 most common types we've already kind of gone through. Traffic stops, really quick. A traffic stop is in fact a temporary detention of a vehicle and is based on reasonable suspicion. Probable cause, or what they call PC, is not the correct legal standard for a stop under the Fourth Amendment. You hear a lot of people when they get stopped in cars, they go, well, officer, what was your probable cause? You don't need probable cause to stop someone. You need reasonable suspicion, which is less of a standard than probable cause. Remember, probable cause is to arrest or search. Reasonable suspicion is a lesser standard. Now, what makes a traffic stop a form of detention? Well, we said it a while ago, would be the display of the red or blue lights or the sirens. That would be the show of force, the red light that makes a reasonable person feel that they are not free to continue on their way and that they have to stop. So I'm pretty sure that everybody kind of gets that. Now, there's another phrase in there. It's articulable suspicion, and it fits right along the line with reasonable suspicion. But the Fourth Amendment of the U.S. Constitution requires searches and or seizures to be reasonable. And in order for this to happen, an officer has to be able to articulate, which is kind of why they use the word articulable, or explain facts and inferences. Inferences are things that people do, or things that you see, or smell, or actions of suspects or whatever that justify your actions. And there are many factors that contribute to this thing called articulable suspicion, and some of them include what we have listed here: an officer's observations of a suspect's activity. Let's say that you're watching an individual inside of a store for whatever reason, and you see them, reach into the drug aisle area or something, and you see them put something in their jacket. I mean, so your observations of activity can help you form the suspicion. The time of day. You're probably saying, well, why does that even matter? Well, think about it. What if you're patrolling in an industrial complex and it's 3 o'clock in the morning and everything's closed, and someone walks out from behind, let's say, a closed building? Could you think in your mind that that's just odd, the company's closed, and because of the time of day, you might need to stop that person and find out what they're doing? Sure. Nature of the location, information received from other sources, what they call wanted posters or informants or anything like that, and inferences from a trained and experienced police officer that would allow the officer to draw a reasonable conclusion. So all of these things help map out this articulable suspicion. So hopefully that kind of makes a little bit of sense. So now that we've kind of talked about that articulable suspicion, well, how long then can you actually hold somebody for or detain them? And I think when you watch TV, they detain them forever, and that's really not the case. So when you talk about length of detention, detentions are temporary, okay, very temporary, and they cannot be prolonged any longer than is reasonably necessary. And you're going to see that word a lot, reasonable, and there's a reason for that. Hey, that was kind of funny. I just made that up. There is a reason for it, and because the justices in most courts will look at different things based on reasonableness. They'll look at use of force based on a lot of different things, and one of them also will be reasonableness. And they'll look at detentions based on reasonableness and searches based on reasonableness. And that's enough for me to say that, but I think you get it. So no longer than is reasonably necessary to accomplish the purpose of the initial stop. Now, if new facts become evident, you could extend your detention a little bit longer. I pull you over because you ran the red light, and I walk up to the car, and my intent is to write you a ticket, and we're conversing back and forth, but as I'm speaking to you, I smell the odor of alcohol or something like that on your breath or coming from the interior of the car. Have new facts now become evident that may make me extend the detention into a different investigation? The answer would be, hopefully you're saying, well, yes, because now you might have a misdemeanor in your presence, meaning that somebody might be drinking and driving. So that's how that works. Now, if during your detention your suspicions are dispelled, meaning that, hey, you know what, it wasn't what I thought it was, you have to let the person go. You have to release the person. You can't hold them forever. Now, if your detention goes the other way and produces something called probable cause, so I smell the alcohol, I see the open alcohol bottle, I talk to you, I determine you're under the influence, then I have probable cause to believe you're under the influence, and now I can search and arrest you. So those are, again, those fall under some of the things that we've already been talking about, but that's typically how length of detention kind of works. So I mentioned a little while ago about this case, Terry versus Ohio, and it is one of the leading cases as it relates to detentions and searches. So Terry versus Ohio, 392 U.S. 1, 1968 case. Look it up. Super, super important, okay? During a temporary detention, an officer may conduct a cursory pat-down search, and this is one of the issues that are out there around pat-down searches, and what they call, there's a phrase out there called stop and frisk. Look up on Google New York PD stop and frisk, and you'll find all kinds of positive stuff and all kinds of negative stuff. And the theory is that officers were out there just patting everybody down, looking for guns, without any reason to really do it. So I'm not gonna take anybody's side on this one here, but just remember, this is a very, very significant case. So during a temporary detention, however, an officer may, okay, not can, may conduct a cursory pat-down search. That search is limited to the outer clothing, meaning you can't stick your hand in somebody's pocket. It has to be on the outside of the clothing, and the officer must have articulable suspicion, remember, to be able to explain, articulable suspicion that that person, that's kind of funny too, that the person is armed and or dangerous. So if I believe that somebody that I'm talking to is armed or presents some type of danger to me, I have the right as an officer under Terry versus Ohio, this super significant case, to pat down the outer clothing to see if I feel some type of a weapon. And if I do, I can remove it and I can arrest you. And if I don't, well, there you go. Now, an officer may use this same principle to permit a cursory search of a person's passenger compartment of a vehicle during a traffic stop. So the same thing would happen if you're the driver of a car and I believe you're armed or present that or dangerous or something, and you possess a weapon, and I have you get out of the car. I can search that compartment where you're sitting and the passenger compartment of the vehicle during a traffic stop. Again, read the case. Super, super significant. Well, what about other people in your car? So we've talked about vehicles, so what about the occupants? Well, during a lawful traffic stop, police are permitted to do certain things. And again, a lot of this is based on what you're seeing as an officer and what you're able to explain or articulate. Now, routinely, we are allowed to order anybody out of a vehicle and have them remain in a neutral location. So a lot of people say, you know, you've heard it before, I don't have to get out of the car. The answer to that is, oh, yes, you do, because we have the ability to do that. So we have the right and are permitted to routinely order all occupants out of a vehicle, have them remain at a neutral location. This order need not be justified by any particular suspicion or criminal activity, just because maybe we feel it's safer. You ever driven by an officer and you've had a couple people sitting on the curb before? So realistically, by law, you can have people get out of the car and have them remain in a neutral location while you conduct whatever investigation that you're conducting. That is your right as an officer. Typically, an officer, I mean, they're not going to put you on the curb just because they think it's funny. Think about it. If you're seated on the curb with your legs crossed, how easy is it for you to get up and attack an officer? The answer would be not very easy. If you were standing face to face, then definitely it would be a lot easier. So this is just food for thought as we talk about searches and seizures and detentions and things like that. The officer also has the right to inspect the VIN number, the vehicle identification number of your car, and the officer has the right to retrieve a person's driver's license and or registration from the vehicle. So these are all things that we are lawfully allowed to do. Now, of course, if there are other circumstances that are present, we can do even more depending upon the circumstances. So now that we've got a little bit of a base or foundation beneath us, we're going to go through this part a little bit quickly because I don't want to spend a lot of time on this, but we've talked about what we can do under certain circumstances. Well, who are we? Well, this is kind of who we are. So this section 830.1 defines what a police officer is, and there's a long list here, but it's any person who comes within the provision of the California Penal Code, which is 830.1, and meets all of the standards imposed by law on a peace officer. And you can see kind of a list of who peace officers actually are. Peace officer status. So there's some sections in there, 830.2 through 10, talk about the primary duty and authority of officers. So you have, highway patrol, you have state college police, corrections, probation, parole, reserve officers and deputies, fire and arson investigators that are armed sometimes, miscellaneous agencies or even, police, state agencies like DMV, alcohol beverage control, forestry, health and social services, insurance investigators, labor. I mean, all that stuff. These are all fall under the peace officer status section to one degree or another. Now, a couple of things that we are required to do here, and there's kind of interesting facts, is peace officers are required to wear a badge or a nameplate. And again, because it's criminal law, there's always a section for everything. It's 830.10, and the rationale for wearing a nameplate or a badge would be for identification purposes, so somebody could know what your name is or know what your badge number is. A peace officer is in fact an officer 24 hours a day, and of course may be called upon on or off duty, and that is an attorney general memo opinion. And so it's not really like built into it's not a case law like we've talked about, like case precedent, but it is an AG or attorney general memo opinion, and this one was from back in 1960. Members of a police department are authorized to carry concealed firearms or other weapons inside or outside the jurisdiction for which they are employed, which means that we can go to different cities armed as well, sometimes even different states. There are ways where we can fly armed sometimes, depending upon the circumstance. So there are some of the benefits to where we can be armed as we move about to different places, because as you just read, we are in fact on duty, in essence, 24 hours a day. And I'll let you kind of fill in some of the other areas as you read through. If you look at page, I think it starts on page 92, and it goes through about 93 or 94. It talks about all the different types of officers that are there and what section they actually fall under. So now we'll get back back into the Fourth Amendment stuff and the search and seizure and laws relating to that. So the Fourth Amendment is one of those that really impact law enforcement. Now, the first 10 amendments to the Constitution or the Bill of Rights, and you throw in the 14th Amendment because you kind of have to, but the first 10 make up the Bill of Rights, and they're all very significant as it relates to law enforcement, but there are some that just really have a huge impact on policing, and the Fourth Amendment is definitely one, so let's look at it quickly. The right of the people to be secure in their persons, houses, papers, and effects against unreasonable searches and seizures shall not be violated, and no warrant shall issue but upon probable cause supported by oath or affirmation, and particularly describing the place to be searched and the persons or things to be seized. Now, I'm not going to spend a lot of time on the Fourth Amendment, but if you go back, it doesn't say that you have the right against search and seizure. It talks about unreasonable search and seizure, which means that in certain circumstances, officers have the right to search and seize. Okay, and it says, you kind of continue on, shall not be violated, and no warrant shall issue but upon probable cause. So I think in the last lecture we talked a little bit about, when you swear an oath. Well, it's kind of the same thing. Now, when you take a search warrant to a judge, you're going to swear the oath, but you're going to also have that warrant supported by an affidavit, which is going to have probable cause to either arrest somebody or to search somewhere. And that's what they're saying here in the Fourth Amendment, that We have ways we can search people and cars and all that kind of stuff, but when it comes to homes and things like that, no warrant shall issue, which means that we can't go get a warrant unless we have probable cause. Because if we want to search your house, we need probable cause. If we want to search your person, we're going to need probable cause. So it's the same thing for both. That standard is there for both, and I think I've kind of beat that up enough. So let's kind of move on to that, onto something else. So what about arrests without warrant? So an arrest warrant is easy. We go get a warrant, we base it with probable cause, the judge signs, we sign, I go find you, and I arrest you. But what about if I don't have a warrant? Can I arrest you without a warrant? And the answer is going to be yes, but the majority of arrests by law enforcement are made without warrants. They truly are. These arrests must be based on the Fourth Amendment standard, remember, of probable cause. And the accused, the person you arrest, must be taken before a judge or a magistrate without unnecessary delay. And we'll talk later about times frames, but basically when you arrest them, you take them, they're going to go to the station, you might process them, take photos, fingerprints, do whatever you're going to do. You take them over to the bigger jail, and you have basically 48 hours to get your report over there, or the person's going to be released. But we'll talk more about that later, but this, again, we're just touching on kind of the surface of things. Now, to arrest a person in their home, we're going to need to do something a little bit different. Your home is your castle, so we can't just like walk in there. So in order to arrest someone in their house, their home, we're going to need to use a warrant. We're going to have to make it pursuant to probation or parole condition. So if you're on probation or you're on parole, and one of the conditions of your probation is you have to submit to a search to law enforcement anytime in your house, day or night, then there you go. Or this thing we call exigent circumstances. And when we're talking about exigent circumstances, we're talking about some type of emergency. And that emergency could be, as I think of an example, we could walk up to a house and we could hear a female, let's say, inside screaming, or a male screaming, it doesn't matter. And we believe that somebody in there, that they were experiencing some type of harm or being victimized or something. We could go in the home to make sure the person's okay. Now, once we got inside there, if we wanted to do anything else or search or things like that, we would have to get consent, or we would have to get a search warrant. Or a fire. We could go in, if we believe that somebody is inside a home and the house is on fire, we have that circumstance, that emergency, where we could go in there. So again, I'm not going to go through all of those. I just wanted you to know that that's one of the conditions, that emergency circumstance. So what gives us the power, though? When we talk about peace officer powers to arrest, well, here are the circumstances, if you will. Now, Penal Code 836A tells us when we can arrest, and it might seem really confusing. So I'm going to try to get this kind of in a way, or put it out there in a way that we can all understand it. So it's going to sound really weird first, and then I'm going to come back. So these are when we can arrest. When the officer has probable cause that a public offense, that's any crime, okay, has been committed in the officer's presence. Okay, I believe you robbed this bank because I heard the alarm go off. I saw you run out of the store with a money bag and a gun in your hand. Okay, I have probable cause to believe that that is happening in my presence. When a person to be arrested has committed a felony, although not in the officer's presence. I am on routine patrol, and an hour ago a robbery happened at a liquor store, and they gave me the description of the person and what type of gun and what type of sack the money was in. And I see you run a red light, and I pull you over, and I see a ski mask, and I find a gun, and you're all sweaty and nervous, and I find a money bag that matches the description. Did I see you rob the store? No. Can I believe that you perhaps did, although not in my presence? Maybe not at that time, but if I get somebody to identify you, then yes, the crime of robbery didn't happen in my presence, but I believe that the person that's being arrested committed that felony, although not in my presence. And then the last one, which is interesting, when the officer has probable cause, remember we need that, to believe that a person to be arrested has committed a felony, whether or not you even did it, whether in fact a felony had been committed or not. So I can give you an example from working a lot of auto theft. I pull a car over with a single occupant, and I walk up to the vehicle, and I ask the person for registration. They don't have any registration. I run the plate. It comes back to somebody different other than him. I ask the person whose car it is. He doesn't know whose car it is. I look at the steering column, and maybe the steering column is kind of cracked open and there's a screwdriver stuck in there instead of using a key, and maybe the door lock on the door is broken. Now, with all of those symptoms there, if you will, after working auto theft, I really do have probable cause to believe that this vehicle could be stolen. So let's say that I arrest the person because I believe this has happened and he's responsible for it, but it turns out that it's not stolen. Okay, that's okay, because I had probable cause to believe that the person to be arrested has committed a felony, whether or not a felony has in fact been committed. Does that make sense? So there you go. So a little bit more about powers of arrest. We talk about officers' presence, and these go along with helping us kind of come up with probable cause and articulable suspicion and everything like that. So officer presence defined relates to an officer's senses like sight or hearing or taste or touch or smell. A public offense, and these are some good definitions, includes things like felonies, misdemeanors, and infractions, because you'll see that any public offense, well, that kind of gives it to you right there. And finally, there shall be no civil liability or cause of action against any police officer within the scope of his or her authority for false arrest, providing they did it properly. And that section's under 836.5 subsection B, and there are some stipulations in there. You can't just go out there and arrest everybody, but again, if you have that probable cause, as I spoke of earlier, you're going to be okay. And when we talk about peace officers' presence, before we get away from the slide, I want to throw that out there. Presence, again, you're probably wondering, well, what does hearing mean? Well, if I hear something and I believe that, and that helps me lend something to articulable suspicion, reasonable suspicion, probable cause, then I can use that. If I smell something, that could do the same thing, like if I pull you over and I smell beer in the car. So that's still officer presence. So that's why they look at sight, hearing, taste, touch, smell. So what are my duties following an arrest? Do I have any duties at all after I arrest you? Well, yeah. An officer shall take an arrested person before a judge or a magistrate without delay. A peace officer may also release a person from custody, any person arrested without a warrant when, okay, so there are some times I can actually release you, okay, if I arrest you without a warrant. The first would be insufficient grounds for making a criminal complaint. So I may arrest you for something and I figure out, I'm not going to be able to make a case here, or the person is arrested for intoxication only. The person was arrested for being under the influence of a controlled substance or drug, and the person is delivered to a hospital or a treatment center, and there's sections that go with this. And then finally, warrantless arrests, again, must be reviewed for probable cause within 48 hours. So remember, I told you before, if I arrest you, typically I have 48 hours to get my report and case together and get all that stuff in. And if I don't make that deadline, there is a good possibility that you could be released. So we talked about officer arrest. So what about private person's arrest? Penal Code 837 covers a private person may arrest in certain circumstances for a public offense committed or attempted in their presence, when a person arrested has in fact committed a felony, although not in their presence, and when a felony has in fact been committed and he or she has reasonable cause for believing that the person arrested committed that felony. So that's a little bit different than the 836 section. And I'm not going to spend a lot of time on private person's arrest. I'll let you read into some of that because I need to kind of move forward and get on some other stuff. Domestic violence calls. Officers are required to make a good faith effort to inform any victim of their right to make a private person's arrest. And again, presence defined is same for private person as for the officer, so it's the use of the senses. And justified in using only reasonable force to make an arrest. So we're still on private persons, remember. they're not justified to use lethal force in making an arrest for crimes against property. And after an arrest, the private person must take a person before a magistrate or peace officer without unnecessary delay. And typically we don't get a lot of private persons arrests. So when somebody brings us those arrests, do we have any type of duty as a law enforcement officer to receive them? Well, we do. Under Penal Code 142, any peace officer with authority to arrest who willfully refuses to receive or arrest a person is technically guilty of a crime. Now, this section does not apply to arrests made by private persons. To avoid civil liability, courts have insisted that probable cause support any arrest made or accepted by a peace officer, including those private persons arrests. So basically, if you go up to section 142, they're talking about two people. Let's just say that two people just are fighting, and you're not there at the initial onset of everything, and you get there and one person says, arrest that other person, he hit me, but you have no supporting evidence, and you can't come up with probable cause to support the arrest. Well, it's telling you here, to avoid civil liability, courts have insisted that probable cause support any arrest made or even accepted by a police officer. So they're giving us a little bit of help when it comes to that. There's also something called misdemeanor citations, which basically means an officer, we don't have to arrest you and take you to jail. We can actually release you at the scene. Kind of like what we do with a traffic ticket, although it's only an infraction. But an officer may use the written notice to appear for any misdemeanor offense which he has or she has reasonable cause to believe the person to be arrested has committed. So if it's a misdemeanor, say littering is a misdemeanor, in some cases, we could write you a citation on a promise to appear in court. And the next one would be for any misdemeanor offense in which a private person made the arrest and delivered the arrested person to the officer. So let's say that someone makes a private person's arrest for somebody graffitiing a mailbox or something, and they bring that person to an officer. We could technically cite release that person and release them from, the police station or what have you with a promise to appear. Now, the citation and release procedure doesn't apply to a lot of different violent or serious felonies, nor crimes involving things like witness intimidation or criminal threats or abuse cases and stalking. Some of those things, we won't release somebody on a citation. So we talked about a lot about articulable suspicion and reasonable suspicion, but now it's like focus in a little bit more on probable cause, because we're starting to get close with our time limit here, but I think we're going to be able to get all this in. So let's talk about probable cause to arrest. Now, under the test of the Fourth Amendment, there's that word again, reasonableness. An arrest must be based on probable cause. So probable cause is defined as this: a state of facts as would lead a person of ordinary care and prudence to believe and conscientiously entertain an honest and strong suspicion that that person is guilty of a crime. And there's a case that goes with it, but we don't have to look at that. Courts look at two aspects of reasonableness when they talk about probable cause. First is probable cause to believe that a crime was prima facie, which means on its face, committed based on the corpus delicti, meaning that we believe on its face a crime has occurred, and we have those elements there. Okay, and then probable cause to believe that the person arrested is the person who committed the crime. And that's how the court looks at the two aspects of reasonableness as they talk about probable cause. Now, in making a determination of probable cause, the relevant inquiry is not whether particular conduct is innocent or guilty, but the degree of suspicion that attached to particular types of non-criminal acts. And there's a case here that's pretty important. It's Illinois versus Gates, and it's 462 U.S. 213. So what we're saying here is that when you make this determination of probable cause, it's not necessarily innocent or guilty, but the degree of suspicion that attach to the particular type of act. Now, specific facts, not hunches, are the requirement of the probable cause standard. So it's not a guess. You have to have some facts, and probable cause is measured objectively. An arrest may be upheld on one ground even if the arresting officer relied on another unsupportable ground. And we kind of need to keep that in mind as well. I would, though, read that Illinois versus Gates case. So the difference now, okay, so maybe this will help clear up some of the legalese. The difference between what we call articulable suspicion, when we're explaining, and probable cause is not the nature of the underlying information, but in the amount. So some factors of establishing probable cause include things like suspect's activity, attempts to conceal things, flight, like running from the scene of a crime, manner of dress, location, time of day or night, prior criminal record, number of suspects, informant information, suspect's appearance, pattern of activity, facts gained by officers and other officers. And these are all probable cause factors that really help you start to gain your probable cause case. So again, there are innumerable factors that could operate to establish probable cause, but I kind of gave you a handful of what they really are. And if I could give you like one example on how you build probable cause, it would be very systematic. So again, let's say that we see a car speeding. It's the middle of the night. It's 2 a.m. And you see a car speeding. They run a red light. So you've got a violation of some sort. So you pull them over. And as you walk up, you contact the driver. There's 2 people in the car. They're super nervous. They're sweaty. And you look on the seat there in between them, and there's a holster, but it's empty. Now, explaining yourself as an officer, start to think this way. You see that holster. What comes to mind when you see the holster? Well, where's the gun part when you see the holster? So let's say that you believe that the people might be a threat or armed or whatever. You shine your flashlight around a little bit more on the floor, and maybe you see a couple of bullets on the ground. Now you're starting to build up that case. Well, let's say that you have enough now to have the people exit the car. And as they do so, in the back of one of their pockets maybe is a knit ski cap that like pulls down over your head with the little eyeballs. And you see a big, huge bulge in one of the person's pockets, so you pat them down for your safety, and it feels like a big wad of money. Do you see how probable cause is starting to build up? Now, what do you think happened based on the set of circumstances that I'm kind of giving you? And maybe we take it one step further and we search the vehicle because we have probable cause and we find a gun. Do we have enough to believe that maybe they just robbed a store? Yeah, we probably do. So that's in essence how you build a case on probable cause. Just one example. But what about those times when people say, well, you know what? You didn't really have probable cause. What you did is you set me up, man. You entrapped me. And I have a real problem. I mean, I have a real problem with this section. So because I don't really understand. I mean, I do as a law enforcement officer and a chief of police. I know what entrapment is. But sometimes I really think that people kind of go to a stretch in trying to use this, because I really believe that people are responsible for their own actions. But I also understand that not everybody's perfect, and there might be some situations to where this could actually happen. But let's take a quick look at it. So entrapment, an act by the police of inducing a person to commit a crime not contemplated by the suspect. Wow. How am I going to induce you to commit a crime? Now, there are circumstances, so I'm not going to say that there aren't. And the reason for allowing entrapment as a defense, so it doesn't get you off, it's a defense. The reason that the courts allow entrapment as a defense is to really deter police misconduct. Maybe, I mean, because we have had not good cops, right? So this is one good way to deter misconduct. Now, the defense should focus on the police conduct and not the defendant's conduct in order to make this work. And the current test is now whether the conduct of a law enforcement officer is likely to induce a normally law-abiding person to commit the offense. And now, we don't have a lot of time, but I am going to give you an example here in just a second, but let's finish this up. So officers, however, may set reasonable traps in effort to apprehend criminals. Meaning, like, can we send underage, under 21 year explorers in plain clothes into a liquor store to see if the person will sell them beer? Yes, we can do stuff like that. As long as we're reasonable about it. Officers may provide opportunities for a crime's commission and may use decoys to participate in the crime. So we're allowed to use a little bit of deception. And again, we don't have a lot of time, but if you look on page 103, it talks about the current entrapment test and setting traps and use of decoys and things like that. Use of informants is essential to detect and gather evidence in a crime. And informants could include minors between 13 and 18 under a court order, someone in custody that you have to really disclose to the jury later on. But and then informants wired for sound, meaning we can send people into places to get information. But take a look at those. But the current entrapment test goes like this. The test is, was the conduct of the law enforcement agent likely to induce a normally law-abiding person to commit the offense? Now, again, it's kind of tough. So here's an example that I'll throw at you, and then we really got to kind of get going to finish up. We've had a lot of burglaries of vehicles. So we'll take a car that's owned by the police department, we'll roll up all the windows really, really tight, and we'll stick a laptop computer on the front seat of the car that has a GPS chip in it. So when the person breaks the window and takes the laptop, it activates the GPS chip. We track them on a little device all the way to their house and arrest them. Now, some people will go and say, hey, I wasn't gonna steal that thing until I saw the laptop there, and then I thought I would do it. Well, that's the reason that we roll up the window, so the person has to make the overt act and break the window and show us excuse me, their desire to take what it is. But we've been challenged on a couple of those types of things. But we can use deception to a certain example. Excuse me. We can use informants. We can set traps, and we can use decoys. And all of those things are listed in there. And then accomplishing the arrest, well, the arrest is made by actual restraint or submission into custody. Persons may use whatever force may be necessary for the arrest as long as such mean is reasonable. A person is never justified in using deadly force on one guilty of a misdemeanor in order to effect an arrest, unless, of course, in self-defense to counter deadly force. And there's a thing out there called a de facto arrest, meaning if there's no probable cause to arrest, the arrest is unconstitutional, and officers and their agencies will assume some liability. So we can't come up with probable cause after we find, if we illegally search somebody and pull the drugs out of their pocket and go, now we have probable cause to arrest you. We can't do it backwards. Okay, we have to do it properly. We have to develop that, have the reasonable suspicion for a detention, and then develop the probable cause for a search or an arrest, and then recover whatever items that we need to recover. So Penal Code 841 talks about the person making the arrest must inform the person being arrested of the intention to arrest, the cause of the arrest, and the authority to arrest. 835A says any peace officer who has reasonable cause to believe that a person to be arrested has committed a public offense, they may in fact use reasonable force to effect an arrest, prevent escape, or overcome resistance. So here's one of those things when we talk about use of force and citizens complaints and things like that on officers. Officers do have the right, okay, to use force, reasonable force, to effect an arrest, to prevent escape, and then to, of course, overcome resistance. Resisting arrest, a couple other sections that we'll talk about real quick. 834 subsection A, if a person has knowledge or by the exercise of reasonable care should have knowledge that he is being arrested by a police officer, it is the duty of such person to refrain from using force or any weapon to resist such arrest. So when we look at the section, and we're going to get to the actual resisting arrest. There's a couple other sections too, but this section should kind of jump right out of you. So if I'm in uniform and people know that I'm law enforcement and they know or should have known that they're being arrested because I'm taking out my handcuffs, they don't have the right to use force, okay, to resist an arrest. It's actually a violation of law. Now, if you believe that you are being unlawfully arrested, you can use the methods that are in place through whatever complaint process or court process to fight that later. But the law is telling you right here, you do not have the right to resist arrest. So, I mean, and this is kind of some things that are out there if people would just actually understand it. And the actual resisting arrest section talks here in section 148. Every person who willfully resists, delays, or gets in the way, obstructs any public officer, peace officer, EMT in the performance of his or her employment when no other punishment is prescribed, is punishable by fine, etc., etc., etc. And then finally at the bottom, just because of all the body cameras and things that are out there, it's not a violation of this section for a person to photograph or make an audio or video recording of an officer. We know that people record all the time, and that's kind of the way it is because now even law enforcement officers are recording. Okay, so we're getting close, and we really want to try to make it within the time frame, and it's going to be really close. We're going to finish up with Miranda. The Fifth Amendment, no person shall be compelled in any criminal case to be a witness against themselves. This was another famous case that I really suggest that you read, Miranda versus Arizona, 384 U.S. 436. The Supreme Court held that compulsion is inherent or built in the process of custodial interrogation, meaning that if you're under arrest, you feel the need or you're compelled to speak, and you really don't have to. The stress of a police-dominated atmosphere tends to undermine a person's free will to speak. You've got the uniform, the gun, the badge, and you look mean, so they might think that they have to actually talk when really they don't have to. They don't have to be a witness against themselves. And again, this is a super, super important case that you should look at. Prosecutors may not use any statement made by a criminal defendant to prove guilt resulting from a custodial interrogation. Now, this is one of those things. I mean, Miranda, you need to Mirandize somebody under certain circumstances. Just because they're under arrest, you don't have to Mirandize them. When two things have to be present, custody and interrogation. If they're not in custody, you're fine. If you're not interrogating them, they're fine. So when you arrest somebody in the field, you don't have to Mirandize them right away unless you are going to interrogate them. Remember, those two pieces have to be there. Well, here is the procedure for the admonishment, and usually officers get them on little cards. So that way we remain consistent on what it is that we're telling people. You have the right to remain silent. Anything you say may be used against you in court, because it might. You have the right to have a lawyer with you before and during questioning. If you cannot afford to hire a lawyer, one will be appointed for you without charge before questioning if you wish. And a lot of times, the card will also have something else on there, like a couple of follow-up questions like, do you understand? Do you understand all the rights I've explained to you, etc.? So a little bit more when it comes to steps following the admonishment. Before the prosecution can offer a suspect's response to custodial interrogation, remember both of those pieces, into evidence, the prosecutor has the burden of proving that the suspect was timely and properly advised of their rights, that they understood their rights, and that if they waived, that they voluntarily waived their rights. If the suspect invokes their rights, meaning like they don't want to talk, any custodial statement obtained thereafter will not be admissible unless the suspect reinitiates further discussion and then waives their rights later on, because they can come back around and decide that they want to talk to you. Here's a little bit more on when it's required. We kind of went over this already. Miranda admonishment is only required when two elements are present. Just keep that in mind. Both have to be there. Neither custody nor interrogation alone will trigger the need for Miranda. It's only the combination of those two that create the need for that particular Miranda warning. And what constitutes custody? Because we know what the Miranda warning is now, so what's the custody part? Well, the ultimate inquiry for custody is whether the person is under formal arrest or restrained equal to formal arrest. So one of those. And the critical factor for custody is whether a reasonable person in the suspect's position would have felt that he or she was under arrest at the time the interrogation occurred. And what constitutes interrogation? Well, the term interrogation under Miranda refers to not only express questioning, but police words or actions that are inherently likely to elicit an incriminating response from the suspect. Okay, and I'm sure you can figure out what that is. Typical booking questions aren't subject to Miranda. What's your name? Where do you live? Do you have any medical problems? Things like that, okay? And then there's something called independent state grounds. People versus May, 1988, the truth and evidence provision of Proposition 8 rescinds the state-grounded exclusionary rule. Violations of Miranda that are inconsistent with the state standards will not be excluded from a criminal court proceeding if they meet federal rules. So if we violate Miranda at the state level, but we don't violate it at the Fed level because there's a little bit of a difference there, it would uphold in federal court instead of in state court, if that makes kind of any sense. A couple other rules and then we'll be done. It's not desirable to over Mirandize. A Miranda warning is not required before each custodial interrogation. Welfare and Institution Code 625 created a statutory duty by police to advise a minor of certain rights consistent with the Fifth and Sixth Amendment constitutional rights when a minor is taken into temporary custody. And regardless of Miranda, a suspect's volunteered statement is always admissible. So if somebody blurts out some type of statement, like a spontaneous statement, or they volunteer a statement, that's different. Those are admissible. The Sixth Amendment right to counsel will be violated if the police initiate interrogation of an accused person after he or she has been indicted or arraigned on a case and has requested or obtained an attorney. So just a couple of little rules right there. And then finally, just to kind of finish up, and I know again it's long, we've gone over a little bit, arrests pursuant to warrants. In order to secure arrest warrants, the courts require an affidavit, and I think we talked about to accompany the complaint. Warrant service for a felony can be anytime, day or night. For a misdemeanor or an infraction, needs to be made between 10 p.m. and 6 a.m. unless you have some of these circumstances down below that are there. Escaping, pursuing, and retaking. So here's just some definition. Escape: a person who has knowingly been lawfully arrested by a police officer commits a misdemeanor by escaping or attempting to escape. Fresh pursuit means close pursuit, sometimes called hot pursuit of a suspect by a police officer. And bail, fugitive recovery is a bail agent. Now on the fresh pursuit, really quick, and again, I know I'm going over, but sorry. We talked about search warrants for homes and things like that, but if you're chasing a suspect and they're fleeing and you're in what they call fresh pursuit and they decide to run up into their house and you run up right behind them and you're right there, you do have the lawful right to follow them into that place and to make the arrest. Now, you can't search or do anything once you're in there unless you get some type of consent or a search warrant, but you still can follow somebody on fresh pursuit. And then posse comitatus is a phrase where a police officer or sheriff may command as many able-bodied people, citizens of the officer's county, as they think may be proper to assist them in overcoming the resistance of maybe some angry crowd or in a fight with somebody or something like that, if necessary, in seizing, arresting, or confining the persons resisting and their aiders and abettors. And I'm going to skip past this here. We're not going to really talk a lot about diplomatic immunity. And arrested person's rights, just kind of to finish up. Within 3 hours after having been booked in, a person has the right to make at least 3 completed phone calls. It's under Penal Code Section 851.5. And again, the officers really have to do this because they are subject to civil liability. Unless otherwise released, They must be taken before a magistrate without unnecessarily delay. We talked about that. And any suspect or arrestee has the right to visitation by an attorney upon request. Civil liability, typical defenses to civil actions brought against police officers are things like this: probable cause for the arrest. So these are defenses that people will use when they initiate civil claims or lawsuits against police officers. They'll claim there was no probable cause for the arrest, or that the reasonable force in effecting the arrest was not reasonable, or that, hey, I was defending myself, it was self-defense, or maybe they coerced me during an interrogation. So all of these are law enforcement and civil liability issues. Okay, so we did make it through a little bit over an hour. Again, I apologize. It is one of the longer lectures, but it is one of the cooler ones as well. If you have any questions, post them on the discussion board, or if you don't want to do it there, email me, and I'll be happy to get back to you. Other than that, that wraps up Chapter 7, Laws of Arrest, and until next time.